Yes, Assalamualaikum warahmatullahi wabarakatuh once again. So for today, we are going to continue with our lecture on the topic damages for personal injury. In the previous lecture, we have covered until LOFE, okay, loss of future earning. And then all of you must remember, in order for the plaintiff or claimant to be able to claim for LOFE, okay, the most important rule is that he's not able to work anymore. Maybe he becomes disabled or for whatever reason, but he cannot work at all anymore. That's why he could be entitled to future earning, okay, loss of future earning. Okay, another question is that what if the plaintiff, okay, after some time, okay, he could recover. I mean, he could be recovering. He was recovering, and then later he was fully recovered, or maybe partially recovered, but he can still start or resume working. Okay, can the claimant, can the plaintiff be entitled to claim for LOFE? Okay, straightforward answer is no. Okay, because why? He cannot claim for LOFE because there is still future earning. Okay, there is still earning. So in that situation, he can alternatively claim for loss of earning capacity. Okay, for the purpose of discussion, we use the acronym LOEC. It refers to loss of earning capacity. All right, and then as you can see here on the slide, I need to mute. Because there was noise just now. All right, go back to the slide. So we're here. So LOEC, it is awarded when the plaintiff can go back to work after the accident. He can still, he can still resume his work. It doesn't matter whether is it after 1 month, is it after a year. So it doesn't matter. So long he can still earn after the recovery from the injury. So we have a list of cases to be discussed today. We are going to discuss Azizi, Amran, and Hizam, and then Dirch. I think we discussed the case previously, but we want to compare Dirch and Tan Kim Chuan. And I remember during tutorial yesterday, one of you was asking about what if the infant, okay, never earn. So can he or she claim for LOFE or even LOEC? Okay, we're going to discuss after this. We also have the case Sanyan to be discussed, and then basically all the cases here. It revolves around the issues is whether in what circumstances, okay, will LOEC be awarded. Okay. All right, so this is the three common situations, okay, in which LOEC is awarded. Okay, the first one, okay, if there is a risk, okay, that the plaintiff will lose his job at a future date, that he might be asked to resign later. And this is we learn from, this is the ratio from the case of Azizi. And then another situation, okay, LOEC could also be awarded when plaintiff can get another job, okay, maybe a new job, fresh job, but now it's with lower salary, lower pay. Okay, so in that particular situation, cannot claim for LOFE obviously, but can still claim for LOEC again. And the third situation, LOEC is also relevant, okay, whenever the plaintiff, okay, when it cannot be proved that the plaintiff was employed at the time of the injury, but he or she has history of earnings before. Okay, for example, in Dutch, okay, we are going to discuss Dutch after this, and we are going to compare with Tam Kim Chuan. Okay, let's have a look at Azizi. Okay, the case of Azizi. The full name, of the case is Azizi bin Amran and Hizam bin Cik Hassan 2006 and decision by Court of Appeal. So it involved accident. And as a result of this accident, and it was caused by the negligence of the defendant. So now plaintiff case suffered from, it's quite serious. It affects the whole lifetime, okay, plaintiff. 4 cm, okay, 4 centimeters shortening. The left leg became shorter compared to the normal one previously. Okay, and because that cannot walk like a normal person anymore. Okay, he walk with a limping gait lah. Okay, or in bahasa we call it tempang lah, more or less. Okay, and then to make the case stronger, okay, there was also medical evidence, okay, that the plaintiff later, because of the way he walked, okay, it will affect, okay, the bones, the joint, okay, the body here. So the plaintiff would later develop osteoarthritis, okay, of the joint, okay, of the joints lah, okay, of the bones, in which he will have to endure more pain and stiffness. So meaning that here, after some time, he will be suffering osteoarthritis. So because of that, even though he could still work, okay, work after the accident. So because of that, the Court of Appeal allow, okay, the claim for LOEC. Okay, that's the reason. I mean, that's basically what happened in Azizi bin Amran. All right. And then if we look further, I mean, if we look deeper and closer to the case here, why? Okay, why did he win the case here? So in this case, plaintiff had actually managed to convince the court. Okay, plaintiff had shown a real risk. Okay, it's not really fanciful risk here. It's real that he would lose his present employment sometime before the estimated end of his working life. For example, working life until 55 or 60. But because of the way he worked, and then he will be suffering from osteoarthritis later. Okay, so he would lose the job, the current job here, the present job here, and then once osteoarthritis came in later, okay, it will be very, very difficult for him, okay, to get a similar job with the same pay. So the pay might be lower, or maybe he could lose the job totally. Okay, and then in order for the court to award or to allow, okay, the claim for LOEC, the court will look at 3 factors here. Okay, first, nature of the work. Okay, and then the age of plaintiff. I mean, the younger is the higher lah, because you have longer expected time for the working life, okay, estimated working life. And then likelihood, how likely, okay, to get another job. For example, okay, if you apply nowadays kind pandemic, now it's pandemic season, a pandemic situation, pandemic world, nowadays is very hard, okay, to get a new job. So the court will take everything into consideration in awarding LOEC. Having said that, okay, there's no specific formula to calculate LOEC. It's just one shot, one lump sum payment. For example, 20K, 30K, whatever amount to be awarded. But usually it will be asked by the plaintiff, and the court will assess whether reasonable or not. And then, the court will allow the claim, or maybe the court will make it higher or lower pay, lower claim here. All right, we go to this next case. Okay, the full name, but the short name of the case is Sanyan. Okay, but the full name is this is High Court decision, but it's very important. So Sanyan and Aziz bin Abdullah suing as the father and the legal beneficiary to Allah Yarham, the deceased lah. Okay, Allah Yarham Muhammad Halil Azni bin Aziz and another. Okay, reported in year 2029. So again, it involved accident, and then the plaintiff came, another to the plaintiff, the surviving one, okay, but one of the victim died, okay, become the deceased here. So as far as the case was concerned, okay, we zoom to LOEC, the ratio here. So the party managed to prove to the court, okay, there was a real or substantial risk that the second respondent, okay, who was second respondent here? Pillion rider, okay, the word another there, pillion rider, he would lose his job or get less employment, lesser pay, okay, and then it will also be reasonable because the case is very unique. If you read the report, you will know, oh, this is the work that he has been doing. They are so young, both of them, okay, the deceased and the surviving one. Teenagers or maybe early 20s, okay, can't remember, or maybe 18, okay, very, very young. So it will be reasonable, okay, this is what the court said, okay, observation. It will be reasonable to assume, okay, that the second respondent will in all probability be engaged in work of a physical nature. I mean, they have been doing the work, for example, taking order for the food, waiter, kind, all physical. Okay, you don't really use mental, that one, just physical nature. And then as far as the injury was concerned, okay, both his right arm, okay, and right thigh, okay, will permanently be 25% weaker than normal. So cannot do normal job like that he used to do. So because of that, okay, you can see, okay, that's the amount of LOEC awarded here in year 2009. He was awarded a sum of 20,000. And this is what we call as LOEC, loss of earning capacity. So taking into account the nature of the work, okay, the age, and then the likelihood, okay, of getting another job. All right, and this is decision by High Court, but then the rule is very important and relevant. Okay, now this is a leading common law case. If you read any English law textbook, you will see this case, okay, in discussing LOEC. The case is Moliker and A. Rirol, reported in year 1977. So plaintiff left thumb, Okay, right, left. Okay, left, thumb, okay, and index finger. Which one is index finger? This one, okay. Index finger were, or is it this one? Okay, were amputated. So 2 fingers were amputated, okay, due to an industrial accident, but he could still work. Okay, without the 2 fingers, can still do the work. He was still working, so he cannot claim for LOFE. Okay, he suffered no loss of earning, but the court allow him, okay, to be entitled to LOEC. He was awarded damages for LOEC. What's the reason? Because the capacity to obtain any other work is weakened after the injury. Mean that here, if he were to work elsewhere, it's very hard to get the job. Okay, he might be losing the present job in the future, and it's very hard for him to get another new job lah, basically. That's why the court allow him to claim for LOEC. So the case name is Molliker, and it's about amputation of 2 thumbs. Okay, 2 fingers, okay, due to industrial accident. Okay, now we want to discuss Dirk, and we want to compare with Tan Kim Chuan. Okay, if you still remember, Dirk was a nurse, kan? She was cycling around the world, and in Malaysia, she was involved in accident, but she was on unpaid leave, so she could not claim for LOFE, because LOFE, she must be working at the time of accident. But for Dirk's case, okay, the court allow her, okay, to claim for or to be entitled to LOEC. Because why? She was working before she went for unpaid leave, so she had history of earning. So it's a very strong reason or basis, okay, to allow her to claim for LOEC. Okay, we compare with Tan Kim Chuan. Okay, this is decision by Supreme Court. Yeah, and it was reported in year 1991. So in Tan Kim Chuan, lower court, okay, award 67,000, okay, LOEC, and the plaintiff, okay, how old was the plaintiff? He was just 12 years old. So I mean, a child, and normally not working lah, obviously, in Malaysia. So 12 years old. So when the case was brought up to Supreme Court quashed the award. I mean, the child could not be entitled to this 67,000 for LOEC. Why is that so? Because plaintiff did not have history of earning, no earning at all to prove that he or she was working here, none. Okay, so if we were to compare Dirk and Tan Kim Chuan here, okay, these 2 cases can be distinguished, okay, distinguishable on this reason. Okay, for the court to award LOEC, okay, it must be proved that plaintiff had history of earning. It doesn't matter the age actually, okay, no matter how young he was, but the younger the plaintiff is, I mean, unlikely, okay, to have history of earning. Okay, what if plaintiff was 15 or maybe 17 or 18, okay, very, very young, but and then maybe he got some allowance, okay, from certain employer, or maybe he was working on part-time basis, or maybe on contract basis. Would that be taken into account? Yes, it will. Okay. So for example, in Marapan, Siti Rama, okay, didn't get salary, but then he was receiving allowance, okay, when the accident happened. So the court allowed the claim. I mean, it was considered as part of earning. Okay, so we zoom to the word of earning here. Okay, basically we are done with LOFE. We have done it before. Now LOEC. So what I want you to be, to understand is that you must be able to identify whether the plaintiff can claim for, is it LOFE or is it LOEC? If LOEC, then there's no specific formula, nothing about multiplicand or multiplier. It's just one shot, okay, award. And then how the court will determine, okay, so there are 3 factors here, and also the trend of the courts lah. For example, what's the latest amount that the court award for LOEC? But again, it depends on all the 3 factors, okay, for LOEC. Okay, we are done with claims in relation to earnings. Okay, now we move to, okay, special damages, okay, or special monetary compensation. Okay, and then usually at least there are two sub categories here. Okay, the first one, loss of earning. So this is actual loss of earning, actual loss of salary, usually up to the date of trial. For example, trial is in December, okay, and accident happened in October. So can claim salary for October, November, December, and after that, the claim will be under LOFE lah later. For example, he is entitled to LOEC. FE. But actual loss of earning, okay, which can be proved by salary slip, for example. Okay, the employer doesn't pay salary because of the injury, okay, because of the prolonged treatment in the hospital, for example. So can claim for this actual loss of earning, but only up to the date of trial. Okay, the most common example, okay, the most common entitlement for special damages here is what we call as out-of-pocket expenses. The actual money that you spend from your pocket or from your wallet, from your whatever, from your purse or from your handbag, whatsoever. So out-of-pocket expenses, basically, that's the term lah, okay, out-of-pocket. So under out-of-pocket expenses here, it could be medical expenses, okay, for the treatment, or it could be as well nursing care. I mean, to take care of the patient. So for medical expenses, we have the case of Chai Yi Chong and Liu Tai, okay, because we have a rule governing this. And other expenses as well, okay, whatever it doesn't come under medical or nursing care, okay, it could be under other expenses, okay, it could be, I mean, it might include, okay, reports, okay, medical report, you have to pay, okay, nothing is free nowadays. And then it also include transport to hospital, okay, to get follow-up treatment, for example, or even the treatment, okay, the treatment when the accident happened. Equipment, okay, repair of vehicle, if it involves a damage to vehicle, calling witness from overseas, okay, to stand, I mean, to appear for the trial, or even for the wheelchair, okay, whatever expenses here. All right. And then just now, this is the first one, okay, number one here, loss of earning, and it will come, I mean, it can be claimed under special damages because it represents only a small loss of earning, which can be specifically proven, usually by way of documentary evidence. Okay, LOFE is just by way, I mean, it is by way of calculation, multiplier and multiplicand. LOEC, that one is the assessment, okay, based on the three factors, and it is awarded by the court, one lump sum payment. So it's different, okay. Loss of earning here, just a small amount of money, okay, provided it can be specifically proven, and it must be pleaded, obviously. Okay, we go to special damages for medical expenses, okay. So it might include operation, okay, to do surgery or operation. If you need, okay, what if it is done in a private hospital? Okay, we will discuss about it later. But now we focus on operation, okay, visits to the hospital, visit to the clinic, outpatient treatment, okay, extra nourishing food, okay, or milk, whatsoever. Cost of artificial limb, okay. Prosthesis, kan, the term, or other incidental related expenses here. And again, because it has to be proved with documentary evidence, receipt or whatever, even eyewitness, okay, so it must be specifically and strictly pleaded, okay, you ask for it, I mean, in your statement of claim when you file the case to the court, and it must be proved, cannot simply claim without any evidence, okay, it has to be strictly proved. Okay, now we are discussing role of medical expenses, especially what if the plaintiff is being treated in private hospital. Even private hospital, it has certain categories, kan? Expensive, exclusive, or normal private hospital, okay? So can the plaintiff recover the full amount of compensation or not here? So the case is Chai Yi Chong, okay? I mean, make sure you know which case that we are referring to, because we have also quite a number of cases with Chinese name, kan? Okay, so be careful with all the names. So Chai Yi Chong and Liu Tai, this is judgment by Court of Appeal. And from this case, okay, this is the ratio or the rule that we extract or we derive. So the first one, if plaintiff seeks treatment from government hospital, okay, general hospital, GH, so the court will allow the whole claim, no further question asked. So you might be asking, well, government hospital free. No, if you check further, okay, nowadays it's no longer FOC, okay, certain things you have to pay, even of operation, or even, I mean, it will be subsidized, okay, the rate will be subsidized, but then it's not really everything free. Yeah, you have to pay a certain amount, okay, but of course, okay, it's not comparable to private hospital, but it's not FOC lah. But what I mean, if the patient is civil servant, kan, that one government will pay lah, but there will be payment actually, okay. All right, so government hospital, no problem. Okay, can claim for the full amount, whatever amount that the plaintiff has paid from his pocket, okay, for the treatment. Okay, if plaintiff seeks treatment from private hospital, so this is quite complicated because most of the time the rule is that, okay, the court will only award 1/3 only. Okay, if the expenses is 90K, for example, so yes, can claim up to 30,000 ringgit Malaysia only, or even sometimes lesser. Okay, that's the rule. But then we have exception to the rule. Okay, is it still possible to claim for the full amount, okay, from whatever treatment in the private hospital? Can, but must really justify. Okay, there must be justification, and this is some of the common justification. The first one, first proof to the court that whatever treatment, okay, that the plaintiff received in the private hospital, okay, was not available at government hospital, or maybe doctors were not available, or whatever, non-availability. Okay, and then another way is that proof to the court that the treatment was available at government hospital, but for that particular period of time, it's not available. Okay, and the plaintiff condition was urgent. Okay, for example, need life support system, ICU or whatsoever, CCU, whatsoever. Okay, so this is all the justification which the court will accept. Okay, and then another reason or another way to prove it is that prove to the court that treatment was available but grossly inadequate. There was treatment, but then it's not really adequate, okay, to cure or for recovery of the plaintiff. Okay, so usually this is the three important justification in which the court might allow full claim. For example, 100K, so can claim 100K. But if plaintiff cannot justify the above, so what's the rule? Okay, only 1/3. It's not zero. Okay, 1/3 will be allowed to be claimed if no justification. Okay, so mean that here plaintiff cannot simply at his whim and fancy straight away go to private hospital. Cannot. Okay, it will be different if plaintiff has insurance and covered by insurance. So don't bother to claim from the defendant, can. But if can justify all these three, so can still claim despite the fact that insurance, there is insurance coverage, can, because insurance is something, it's not really a matter, it's not really something that defendant should be bothered with, can. Is plaintiff private matters, personal affairs. Okay, that's basically medical expenses. We have actually a number of cases, maybe in your textbook or maybe in your course online or whatever you're reading or supplemental reading. Okay, you can have more than more cases lah. Okay, but for lecture purpose, we don't have many cases. Okay, now we move to nursing care. Just now, special damages for medical expenses. Now, nursing care. Can the plaintiff claim for the cost of nursing care? The answer is yes. Okay, it is under special damages. So a claim for nursing care can also be made by the plaintiff if extended nursing is required after the accident. For example, after being discharged from the hospital, so the plaintiff requires still nursing care. Okay, care lah basically, right, at home. And even if the relative was the one who take care of the patient, can still claim actually. Okay, the court. All the questions here, I'm just answering it. Okay, will the court entertain a claim of nursing care for the relative? The answer is yes. Okay. All right. And this is the case. Again, we go back to the same case again and again, Marapan Siti Rahmah. So, in the 1990, okay, the court held that the trial judge was correct. Okay, the court upheld the observation by trial judge that nursing care was justifiable, okay, and should not be any less, okay, if the person concerned was looked after at home instead of institution. Okay, no need to send to a special institution, okay, to take care of the plaintiff. And then it's also settled that compensation can be given in money for services rendered by parents. So even if a parent was the one who is taking care of the plaintiff, can claim for nursing care as well. Okay. And then in this particular case, Marapan Siti Rahmah, what's the amount awarded, okay, in that year? 350. Okay, why such a low rate here? There must be reason. So if you read the full report, then you will know lah why the court allowed the claim of 350 for nursing care. Okay, for common law case, we have the case of Housecroft and Bernard, decision by Court of Appeal in year 1986. What's the important here is that the rule, okay, that we derive. So the case says clearly that where a relative provides care, okay, out of love, okay, the compensation, the damages should include a reasonable recompense to the relative. It doesn't matter whether, for example, other than parent could be sibling or maybe cousin or auntie, uncle took care of the plaintiff because of love, pure love here. But can they also claim for compensation? Yes. Okay. And one more, if relative give up work. Okay. So in that particular situation, okay, the court will award a sufficient amount to ensure that he does not lose. Okay, I have 10 minutes left. Okay, he or she does not lose as a result. For example, he was working and then he was earning 2,000, and then he give up the job to take care of the sibling, for example, sister or brother here. So can he claim for the 2,000? It depends. Okay, it depends because the court will look at the ceiling rate. Okay, the commercial rate. Well, usually nursing care in Malaysia, how much for a month, for example? Is it 2,000 or is it 1,000? If commercial rate is 1,000, then plaintiff, the one who take care, the one who give the nursing care can claim up to 1,000 monthly. Okay, it depends on the commercial rate. Okay, and will inflation be taken into account? The answer is yes lah. Basically, that's why it's very important for us to look at the latest case to see what's the latest amount or trend awarded by the court. For example, in the case of Raji Transport and Idayu, reported in the year 2004, decision by High Court. But then this is actually appeal from Session Court to High Court. So appeal against the decision of Session Court in awarding 30,000 to the respondent, okay, citing two similar cases. When the appellant appeal, appellant cited two similar facts cases but with lower award. Okay, that's why he was appealing against the higher award here. But the court held, well, the award is reasonable. 30,000 here is reasonable because the two cases that you quoted or you cited, okay, here were decided about 2 decades ago. Not 2 years ago, 2 decades ago lah, 20 years ago. So 12,000 and 60,000, okay, 20 years ago, it will be more or less case similar value of 30,000 for the year 2004. Okay, that's basically the observation by High Court. So we are done now with all. Okay, we started with general damages. Okay, we discussed pain and suffering, loss of amenities, mental anguish, and the injury itself. And then we focus on loss of future earning. Okay, and then you must be able to know what's the multiplicand and multiplier. And just now we have done. Okay, we have completed the discussion on special damages, which focus on loss of earning, small amount, okay, up to the date of trial, and other out-of-pocket expenses, which might include medical, nursing care, and all other expenses actually incurred, okay, by the plaintiff. So with that, we complete the discussion on the topic damages in personal injury. So I stop share.